Hi, I'm Paul Mallis, partner in the law firm of Young, Marr, Mallis and Associates. Welcome to the Paul Squared podcast. I started my career in the district attorney's office, and in 2016, I turned my focus to exclusively defending clients charged with crimes. I created this podcast to provide an overview of the criminal law process and to answer the questions I most often get when I first meet prospective clients. My goal is to protect my clients' rights and to guide them through the stressful process of being charged with a crime. While this podcast serves to provide general guidelines around the practice areas we discuss, you should always consult directly with an attorney to make sure the specifics of your particular situation match up with the applicable laws. The decision of choosing an attorney is an important one, and you should give it careful thought before deciding. If you need representation or just have questions, please don't hesitate to contact me at 215-639-5297, or you can visit our law firm's website at www.ykacrim.com. That's ykacrim.com.
All right, so welcome back to another episode of the Paul Squared podcast. Today, I am joining Paul Mallis, a partner of the firm Young, Marr, Mallis and Associates, and a criminal defense attorney. Paul, how are you doing today?
I'm doing very well. Thank you for having me. Thank you. Glad to be here again.
Yeah, it's a pleasure. So today's episode, we're going to be covering a recent ruling in the Pennsylvania Supreme Court regarding ARD for first-time DUI offenders. In this ruling, it is now where it's not considered a prior offense for ARDs that can be considered in subsequent DUI charges. So we're going to break it down step by step. And Paul here, with his knowledge and expertise, is going to be breaking us through and talking about this ruling and going through everything that way. So it's going to be far more digestible and better explained than I could ever hope to do so. So just to start, for those of us who might be joining us for the first time and don't entirely know what we're talking about, can you just explain what is the ARD program in Pennsylvania and what is ARD?
Sure. Well, essentially, it's a program designed for people that have never been in trouble with the law before. It's a program for first-time offenders, people who made a mistake, and it allows them to come out of this without a criminal conviction. ARD, it stands for Accelerated Rehabilitative Disposition, ARD for short. It's a mouthful. But again, it's a program designed for first-time, we say, nonviolent offenders, and it allows somebody to come out of the criminal justice system without a criminal conviction, essentially.
So in this case, it's not just strictly correlated to DUI offenses, correct?
No, it could be for anything. In fact, I had a client last week who had a non-ARD type matter, and the matter had resolved by way of ARD. So ARD can be for DUI cases, or we say non-DUI cases that are not DUI related. So it could be for anything.
So in particular for today's episode, since we're talking about how ARD is going to affect from this Supreme Court ruling for DUI cases, can you tell me a little bit about why ARD has been so important for first-time DUI offenders?
Sure. So DUI law in Pennsylvania is very strict. It carries mandatory penalties, and those penalties are based on what one's blood alcohol concentration is and how many DUI offenses the individual's had within the last 10 years. So the law looks back to 10 years. It says, how many DUI offenses have you had, and what is your blood alcohol concentration? Okay. Majority of the time, there's mandatory periods of incarceration that are associated with a DUI. If your blood alcohol concentration is above the legal limit, there's a mandatory jail sentence associated with that. And so what ARD does is it avoids those mandatory penalties. It eliminates the jail sentence. It substantially reduces your driver's license suspension, and it allows you to come out of this without a criminal conviction. So that's the benefit of ARD.
Before we go more into the ruling, because we'll get into more details and specifically, how it's going to be also affecting more people and kind of just break down that topic a little bit more. How did ARD affect someone who later got a second DUI?
Well, their second DUI would be, in fact, a second DUI offense, subjecting them to second offense penalties. So if you got a second offense DUI and your blood alcohol concentration was above a 0.16, you'd be looking at 90 days of incarceration versus 3 days of incarceration. So you can see
That's a pretty
there's a big
substantial difference right there. Yeah,
pretty substantial. And if it was, listen, if it was the case where they got arrested, it was a third offense, a third DUI arrest, but their very first DUI arrest was ARD, then the most recent arrest would be their second. And so we would be talking about a 90-day period of incarceration versus a 1-year period of incarceration potentially. So the law is definitely beneficial to drivers getting arrested for DUI.
From your perspective, though, as a criminal defense attorney, sounds like there might be more pros to the new ruling and kind of cons to the old one. But just to kind of look through both kind of perspectives of what people, prosecutors and criminal defense attorneys can be looking at for this ruling and how it's affecting things, how would the previous law have been looked at? What are the pros and cons that the previous rulings would have affected in terms of the law in the old system?
Well, the previous ruling was that ARD counted as a first offense. So if you got a second or subsequent DUI offense, then it counted as a second or subsequent DUI offense. So it's really just as simple as that. The previous ruling treated ARD. If you got arrested for a DUI and your matter resolved by way of ARD, that counted for purposes of what number DUI offense you were looking at today. That's how the previous law worked.
Now that we look through some of the old stuff, let's break down a little bit more of what the new Supreme Court ruling decided. Can you just explain, in simple terms, what the new Pennsylvania Supreme Court decided?
Basically, I can explain what the court decided and the rationale behind it. The decision was that if you got arrested for DUI and your case resolved by way of ARD, that did not count as a conviction. Why is that significant? Because if you get arrested for a second or subsequent DUI, that previous DUI where you got ARD doesn't count as a conviction for sentencing purposes. So if I got arrested today for a DUI and 9 years ago I got arrested for a DUI back then, and that DUI 9 years ago I got ARD, under the old law, my DUI today would be a second offense, and I could be looking at a period of incarceration of 90 days. But now, under the new law, my DUI today is going to be a first offense. The law is not going to look to my DUI 9 years ago. It's going to say today, that's my first offense. And my exposure is going to be a lot less. My exposure will be much more reduced under this new version of the law here.
That's a very significant difference right there.
It is. It is. And I'll just say this, the ruling, I think it's important to understand the court's ruling too. Basically, what the Supreme Court said was that you can't count ARD as a conviction for sentencing purposes because there was never really an admission of guilt or an admission of facts. And if there wasn't an admission of guilt and an admission of facts, then there was never a conviction. And if there was no conviction, how do we count that as a prior offense for DUI sentencing purposes? And I think that that's really like the rationale that the court has been going back and forth on. It's violative of our due process rights here. And if you never made an admission of guilt, it really shouldn't count against you. And I think that's really what the court kind of rested its holding on.
Yeah, I'm glad you mentioned that as well, just because, even from my standpoint and as an every day-to-day person, you're never going to think about some of the details and the specifics, the rationale that comes behind this ruling, especially when you go through the process.
No.
This is what you need a criminal defense or a DUI attorney for, is to
Right.
understand this process, because even as you're going through, like you said, ARD, even if you had something that happened, 10 years ago, as at this point, you're not necessarily thinking about the impact that that's having today and how the court is looking at things from one point or another. But where you're looking through someone's previous history, you're kind of looking at the big picture leading up to their current arrest or current offense. These things do matter, and the way that you're going to perceive them and also be able to better help and defend your client is extremely important from
right. And it is. From the client's perspective, the client just wants the best possible outcome. They don't care what Supreme Court's rationale was, or the reason behind the ruling.
Right.
They just want the best possible outcome. But what we've been seeing here, especially when this holding just came down, is the current existing cases that are already in the system but haven't reached a final outcome, or we say disposition. This ruling is affecting even the current cases that are in the criminal justice system to the client's advantage. So we've seen a number of clients who, got arrested earlier in the year prior to the ruling being issued, and now they're getting a much different result than we anticipated when we first got started.
This kind of leads into one of my next questions, which is why and is this ruling creating some confusion within the system? And it sounds like in some ways, yes, it is, because this ruling, how it's affecting both previous cases and cases that are currently in the system. It's kind of one thing if you're going to end up getting arrested and it's going to be your first offense ever, but for people with previous convictions and those currently going through the process, it's definitely caused some alterations in how things are being handled right now.
Oh, for sure. Yeah. I mean, some clients are catching like a windfall break here, right? I mean, what would have been a third offense, subjecting somebody to a mandatory 1 year prison sentence, is now being treated as a second offense. And what would have been treated as a second offense is now being treated as a first offense. And I mean, and down it goes from there. So every case is kind of being treated differently. And I think that, from a prosecutorial perspective, a prosecutor who's looking at the case needs to obviously they need to uphold whatever the land of the law is, the law of the land, I should say, whatever the law of the land is. But at the same time, I think a prosecutor is going to look at like principles of fairness, right? Like what is fair here? If this is somebody's third DUI offense and they're catching a huge break, a prosecutor is going to say we need to still, there needs to be a punishment here. And so then that begs the question, well, how are the different prosecutors' offices handling this new law, which I'm happy to speak some more about as well.
Yeah, you're jumping the gun. You already know exactly what I'm going to say before I say it, which is from your perspective, because you're working in multiple courts as well in southeastern Pennsylvania as well. How are things being handled, and how are things looking different on a county by county basis and in the different courts? How's that changing things, and how the flow of things is happening in your world as well?
Honestly, the short answer is I don't know, because we're kind of swimming in unknown territories right now. This law had changed the way the law is right now. It had been in 2017 or 2018, I want to say, and then it reverted back where ARD did count as a first offense. And now in 2025, fast forward, we're now back to, again, where ARD didn't count. So I can tell you that back in 2017 or 18, when the court had ruled that ARD didn't count as a first offense, what a lot of district attorneys' offices around the southeastern Pennsylvania area were doing is they were giving offers to resolve cases beyond the mandatory minimum law. So if this was a second DUI offense, and under the law as it stands now and how it was back in 2017, under the law, the prior ARD didn't count. So now your current offense was a first offense. You could be looking at a mandatory 72-hour jail sentence. Great. That's great. So the client went from 90-day period of incarceration to a 3-day period of incarceration. And the DA is saying, well, wait a minute, come on now. I understand I have to follow the law here, obviously, but the client, there has to be some sort of punishment here. And so what we saw the DAs doing back then was they were saying, I'm going to give an offer to resolve this case beyond the mandatory minimum law. So instead of an offer to 3-day prison sentence, I'm going to give 30 days, right? I'm going to give beyond the floor here, because I know that by law, I can go up to a certain point, and I'm going to give a little bit more just to teach a lesson. And hopefully we don't go back to that. But I have the feeling that we're going to be seeing a lot of prosecutor offices around this area of Pennsylvania start resolving cases in that fashion. So And what that's going to result in is a lot more DUI cases getting tried. There's going to be a lot more trials with these DUI cases now. So that's kind of where things stand, though.
Gotcha. Do you know, even from your own experience, any examples that where ARD has been denied due to this update in ruling? I guess is the better way to say it from the pendulum perspective.
Yeah, sure. We are being told that one county in particular is not offering ARD anymore. Now that I have not had a client in this county since this new ruling was handed down. I don't think our firm has had a client in this county since the new ruling, but we're being told by prosecutors and fellow criminal defense attorneys that this particular county is saying no ARD for DUI cases now. And they're within their right to do that because ARD is it's a privilege. It's not a constitutional right. The district attorney and only the district attorney can offer the program. The court, the judge, has nothing to do with whether or not a client receives the benefit of ARD. So I think that's extreme to not offer, a first-time offenders program. To get a young person that made an honest mistake, and for that person not to be given a benefit like a first-time offenders program, I think is harsh. But we are being told that this one particular county is not offering ARD in light of this new ruling.
Wow. And I guess to build off of this point, another question that kind of popped into my head, especially as we're coming to the end of this, in the event that this ruling doesn't stand and we revert back to kind of the previous way that things were, what does this look like from your perspective, and how do the courts handle this, where it can be one way for a couple years and then switch back and then switch back again? How does that affect people as kind of they're going through the program as well, and as their cases being handled within the courts?
Well, I think once once their case has been resolved, either by way of admission into the ARD or by way of a guilty plea conviction, the case is resolved. There's been closure. I think that you have that category of people where their cases are over. You've got a category of people who are going within the criminal justice system, and if the pendulum swings back and forth, then the people that are currently in the system are going to be subject to whatever way the pendulum's swinging. And then you have the people that haven't even incurred an arrest, that aren't affected of it. They're not affected by it at all. So I think that however the court lands on this, we're just going to have to wait and see how these cases are treated and whether or not the decision reverts back again.
Just to wrap things up, because I think you've gone through all the questions that I've had, especially regarding this ruling, is there any last points or anything that you would like to make about this ruling or the ARD program in general that viewers or anyone might be interested to know, or you think is important to mention?
I think it's a wonderful program, and it's designed for people that have never been in trouble with the law before. I think that people that are finding themselves in the criminal justice system by way of an arrest for a DUI need to know that ARD is an option, and they need to avail themselves of that opportunity, and they need to have a lawyer that understands the inner workings of how this new law affects people that are going through this process.
I think that's well put right there. It's going to be an important thing, and I definitely encourage anyone that if they have questions on anything to reach out and definitely look into the program. If they're experiencing anything, reach out to a criminal defense attorney. Don't wait on this matter, especially when it comes to understanding the law and any of these changes. This is what they are for, and this is what they're going to do. They're going to help walk you through it, and they're going to make sure that you understand what's going on every step of the way.